Namaskaram, Vanakkam, the South Indian is here. Have you noticed how three chief ministers of South India have an extremely difficult relationship with the governor? You must have read several reports. That's what we are going to talk about today. Tamil Nadu Chief Minister M.K. Stalin and Governor R.N. Ravi's clashes galore is now legendary. K. Chandrasekhar Rao, who is also known as KCR, Chief Minister of Telangana, has clashed with Dr. Pinarayi Vijayan many times. And of course, Kerala Chief Minister Pinarayi Vijayan colliding with Governor Arif Mohammed. Just a few hours ago, Tamil Nadu Governor R.N. Ravi had yet again raised the hackles of the ruling Dravida Munnetra Kazhagam and M.K. Stalin when he equated India's hosting of G20 with celebrating Sanatana.
The whole world celebrated Sanatan Utsava in Delhi when we had the G20 summit. Because G20 summit under Bharat's presidency was done with the full commitment to Sanatan values, Sanatan Dharma, Vasudhaiva Kutumbakam. What we say here in Tamil, Yadu Mure, Yadu. Today, the world has begun celebrating Sanatana Dharma.
You know, in that very speech, Governor Ravi used a word indestructible, I beg your pardon, which is obviously a veiled jibe at Udayanithi Stalin's statement when he spoke about eradicating Sanatana. Also, when Telangana Governor Dr. Tamilisai Soundararajan rejected the nominations of BRS leaders, Dr. Sravan and Kurra Satyanarayana as MLCs under the governor's quota as requested by the state government, it was yet another round of acrimony between Telangana Raj Bhavan and Pragati Bhavan, where actually KCR operates from. KTR, the working president of BRS, lashed out at the governor and commented how she was unfit to hold the position of governor. In the latest, ladies and gentlemen, it is the clash between Chief Minister Pinarayi Vijayan and Kerala Governor Arif Mohammed which has now escalated beyond proportion. Pinarayi now plans to seek legal opinion, and the reason being 8 bills which were passed by Kerala Assembly are still pending with the Raj Bhavan. This has also now forced Pinarayi to approach the Supreme Court on whether the governor has the power to sit on the bills indefinitely. When asked about approaching the apex court, Vijayan said, and I quote him here, 8 bills were submitted to the Raj Bhavan. However, even after a long period, they have not become law. When the governor, that is Arif Mohammed had sought explanations and clarifications on the bills, the ministers and the officials concerned had visited him and given the required explanations. However, no decision has been taken on the bills. That's what Pinarayi Vijayan said. Now, of the 8 bills, there is the University Law Amendment Bill, which the Assembly had passed 22 months ago, which the Chief Minister said had put the appointment of VCs in a limbo. Second, and in terms of priority, is the Public Health Bill 2021, which is also pending with Governor Arif Mohammed. Even as Pinarayi questioned if this was constitutionally proper, he also added that most pending bills are about the aspirations of common people and actually at variance with parliamentary democracy. On his part, Governor Arif Mohammed actually welcomed Chief Minister Vijayan's suggestion to move the apex court. Listen in.
I welcome it. It is a very good, I mean, it should be welcome, because if they have any confusion in their mind, then it will be cleared. In Trivandrum, it's very good if that is the position. If they have some confusion in their mind, there was some confusion in the mind of the Telangana government, that was cleared. If they have some confusion, it will also be cleared.
So I'm asking you, we need to understand what rights does a governor have in so far as sitting on bills, like all the chief ministers, whether it is Muka Stalin, whether it is Pinarayi Vijayan, have said that you sit on bills indefinitely. So does the governor have that right? Is it binding on a governor to pass bills as ratified by the state legislature? Is it only and only politics which results in such overt slugfest? Now, what does the common man do when faced with such a situation? Let's start a debate. Let's look at this debate from all angles. Of course, there is politics, but there is also polity. There is also policies, as it were. Let me now welcome the guest to my show, Sebastian Paul, who CPIM, leader of the CPIM, is now joining us. Lieutenant Commander retired Gokul Chandran, who is a very well-known political analyst, is also with us. And we shall also be joined by Satish Kumar, who is advocate with the Madras High Court, and M. Rajendran, who is a senior journalist. Namaskaram, and very nice to see all of you here. Very nice to see all of you here. I want to first start with Mr. Paul. Mr. Paul, this is not the first time, when we have seen Mr. Vijayan actually, having this overt, open, almost bordering on aggression kind of a slugfest with Governor Khan. We'll talk about the Sarkaria Commission later, which actually listed what the rights and the duties of a governor is and the center-state relations, as it were. But I'm asking you that, time and time again it happens. Of course, Tamil Nadu, it's been happening. It's happened in West Bengal also, sir. But I'm only talking, being the South Indian, I'm only going to talk about the South. What is it? Is it just purely politics, you think? Someone may see it as, come on, Governor Khan is only doing his duty. I mean, if he's supposed to be pliable, then what's the point of him being a governor? Your reaction, Mr. Paul?
The governor's constitutional duty is to give assent to the bills passed by the legislature. Here, our governor, Arif Mohammed Khan, is refusing to discharge that obligation. In a British model parliamentary system, the role of the governor, the centrally appointed governor, is well defined, not only by Sarkaria Commission and other commissions, but also by the Supreme Court in illustrious cases like Bombay case, etc. Everything is there, everything is clear. But our governor, Arif Mohammed Khan, at the behest of the ruling party in the center, he is playing politics. It is really unfortunate and painful to see an popularly elected chief minister and the nominated governor are at loggerheads over the issue of discharging a constitutional function. As you have just now mentioned, it is for several months the governor is sitting over bills which are passed by the legislature in its legislative competence. What is the reason? If he has valid reason to object to the passing of a bill, there is constitutional methods and procedure for him what to do.
Mr. Paul,
he has to.
Yeah, Mr. Paul, I'm sorry to be interjecting, but I will just take the viewers through one other instance. There was a flashpoint when Governor Khan had demanded the resignation of the VCs after the Supreme Court verdict that the appointment of the Vice Chancellors of APJ Abdul Kalam Technological University in Thiruvananthapuram was illegal. Now, would you see that as a very, very logical reason for, registering a protest? You said, does he have a reason? There are constitutional measures. But first step to any constitutional measure, even if I have to go to court, is basically complaint. So, any complaint that he lodges, there seems to be immediately, there is innuendos about RSS, about BJP. So, do you think it is only politics which makes Governor Khan and Pinarayi Vijayan government not see eye to eye at all?
No, it is nothing but politics.
Okay,
because
sir.
we know we know in our system, the governors are appointed by the ruling party at the center. When the ruling party is at the center and the states belong to different categories, this always happen. This is not only happening in Kerala alone. What is it, Tamil Nadu, in Telangana, in West Bengal, everywhere these BJP nominated or appointed governors are at loggerheads with the chief ministers. They are creating obstructions, unconstitutional obstructions for the government to function. That is what is happening in Kerala also. If the governor, in his wisdom, is disagreeing to a legislative proposal, there is method, there is a procedure prescribed by the constitution for him to act. His inaction for several months without assigning any reason is unconstitutional, nothing but unconstitutional.
Right. Let me go to the lawyer now, because let's understand, and then I will go to Gokul and M. Rajendran. Satish, I want to know, taking from what Mr. Sebastian Paul said. He said there are constitutional methods, but my contention is that when the governor registers his protest or says no to something, immediately it's given I am not saying it's unfair, but it's seen through the prism of politics, Satish. The point is, suppose I am the governor, okay, and I don't give assent to particular bill. What constitutional measure do I have to register my protest even further, Satish? Is there a constitutional provision for that?
Namaste. First of all, in this issue, now we are seeing in the current trend, many governors are conflicting with the legislative assembly, and especially with the chief ministers. And the allegation is generally is that always it happens when the opposition party, which is a non-BJP party sitting in any state, they are having a conflict with their governors. That is a general tendency. And I personally feel that even governor nowadays have been brought into the political scenario when such situations were not there previously. But nowadays, when the governor says something, even in as a public speech, that has become a politics by the ruling party members. And I think in this issue also, the governor's stand of whether to give assent to the bills or to send back for reconsideration, that is a general constitutional provision under 200 and 201. It happens. A bill can be accepted or maybe sent back for any suggestions. And in this case, it's quite surprising that the Honorable Governor has rejected it, because so far the bills being rejected has not happened so far. Bills have been kept pending, or sometimes it has been sent for consideration. But in this case, our Honorable Governor has said that he is going to reject it. So this is quite a different scenario. That's what I feel from my situation.
Yes, and also I'm going to talk to you about, that then the chief minister, that is Pinarayi Vijayan, saying, I will go to the apex court, to the Supreme Court. And I think in the recent history, past history, one hasn't seen this legal route being taken. Of course, there is politics about who you are, who I am, what do you support, Sanatana, etc. Tamil Nadu is now governor and chief minister story is almost every day making headlines, right? Mr. Rajendran, welcome to the show. Mr. Rajendran, this what Pinarayi Vijayan has now said, I will go to the Supreme Court. It's because of 8 bills which are pending, the public health and also other important bills which are there. Mr. Sebastian Paul just spoke and he said, look, it is of course about politics. But I have a question to ask you. If this is how politics is being played out, what happens to people whose lives depend on those bills? I vote you in, if I am a voter, I vote you in so that you can also legislate for me. But this has been going on and on. The purpose itself is lost, no? It becomes counterproductive, Mr. Rajendran.
So, Sudha, just to start my argument, I have a small quote of Dr. B.R. Ambedkar, which has been quoted quite often, but it has become more relevant now than ever, is howsoever good a constitution is, if the people implementing it are bad, it will turn out to be bad. And howsoever bad a constitution be, if the people who are implementing it are good, it will turn out to be good.
Right.
So that's where the whole argument lies. Let's take the next step, the Sarkaria Commission. I'm sure earlier speaker had mentioned about it. There were two critical points which I want to highlight. One was that they had said that the people who are appointed should be seen as somebody who would be supporting the efforts of the state government in serving the people. If you look at the debates of the Constituent Assembly, where Pandit Jawaharlal Nehru and Alladi Krishnaswamy had very categorically mentioned the role of governor and what it should be. People have forgotten those things. So you coming back to politics, you have voted, I have voted, and we want our services to be given by the government. And if a governor, if the person is seen to be obstructing the whole process and not facilitating it, you as a governor, if you are a learned governor, and you have some objection to it, you could probably send it to the president, and president can have a look at it. There are mechanisms to do it, but to hold it and not allow it to allow the elected government to function is something just not politics.
Yeah, so what you're saying, Mr. Rajendran, is that it becomes the synergy is lost, there is no synchronization, work is stalled, and it is only about getting political brownie points, at all levels. You do this, I will do this, you do. It's like children playing, and it's revenge taking. Gokul Chandran, what Mr. Rajendran said very rightly, that it is about working together for legislating, for helping the people who are there. Now the thing is that the Pinarayi Vijayan government has time and again seen everything through the prism of its ideology. I mean, you say something, they'll say, oh, you are an RSS man, you do this, you'll say, oh, it is Hindutva. So do you think that on both sides, and I am not blaming just one side, I am only talking about the common man, because those 8 bills which are pending, it's not only about Mr. Pinarayi Vijayan or his cabinet members, it's about those many Malayalis who reside in Kerala. Do you think that it is time that this kind of, let's, like Rajendran says, that let's then have governor who can work with a particular chief minister? Do you think that kind of a change is required now?
Yeah, good evening, Sudha and my fellow panelists. See, the one thing is sure that BJP, whenever they cannot come to power in a state, they try to run the state through the Raj Bhavans of that particular state. The same is happening in Tamil Nadu, Kerala, or Telangana, or whichever state. See, these 8 bills were passed by the Legislative Assembly, where 140 MLAs have cleared the bill, and the governor has no business. I'll put it in a blunt, bold way. The governor has no business to stop the bill or even check on the bill, because it has been cleared by the Legislative Assembly, and the role of governor is just to sign it and clear it. See, we have discussed earlier regarding the ordinances, the appointment of VCs and all. Yeah, I agree to that the governor has some say, because he's the chancellor of the universities, or he's the head governor of the state, and he can ask the government or the ministers regarding the ordinances and appointments. But regarding the bills should be cleared. Henceforth, nothing should be kept pending. That should be the role of governors of any state. Let it be a BJP ruled state, let it be a Congress ruled state. Tomorrow the roles may reverse. The Congress might come to power in 2024 and BJP
Gokul, wait a minute. I know that governor is a constitutional appointment, But the point is, if everyone is going to agree with everyone, then what happens in democracy? Even in the same party, I may be fighting with you. I don't agree to certain things.
The governor doesn't have any right to agree or not agree.
No, I wonder if because I will ask Satish, we've lost connection to Satish, whether the word is right. I mean, I do think he has a right. Otherwise, if he refuses, now in this case, in Kerala's case, he's rejected it, Gokul. It is not that he's kept
No,
it in
no,
abeyance.
Sudha.
There is a difference between
See,
abeyance, there is a difference between
it is
rejection and abeyance. You know, so the thing
it is an understanding.
Yeah, go on. Go
Yeah, Sudha. It is an understanding which was going on between the state governments and the governors that the bills will be passed, cleared, and it will come. If it is a controversial bill, something related to place of worship or religious identity, then I can understand. But these are all of public importance and public emergency. I'm not saying Pinarayi Vijayan does everything right. Pinarayi Vijayan also, many times he takes the shortcuts and he tried to pushing the bills and pushing the ordinances. In this case, if the 8 bills are passed by the Legislative Assembly,
Right.
then the governor, who is, he doesn't have any role, he doesn't have any constitutional authority to hold on to the bill.
Mr. Paul, Mr. Vijayan has now said that he will approach the apex court. Now, is he seeking legal advice, sir, even as we speak? I mean, apparently he has spoken to some very prominent lawyers about the forward step. What kind of a step do you think Vijayan will take?
So definitely, our Chief Minister Pinarayi Vijayan might have consulted legal luminaries or available best tenants in the field of law before approaching the Supreme Court. This will, I think, after SR Bommai case, will come out as a most important or an illustrious case involving the tussle between the governor and the chief minister. The Supreme Court has to decide the issue. The Supreme Court has to tell the governor about his responsibility, his duties, and what he should do when he receives a bill duly passed by a state legislature. Legislature means governor is also part of the legislature. Governor is the head of the executive as well as part of the legislature. It is his duty to give his assent to the law, bill passed by the legislature. He can refuse it. He can refuse to approve it. He can refuse to sign it. He can send it back to the legislature. He can refer the case to the president. Right. All those things he can do. But here he is doing nothing, and it is nothing but constitutional irresponsibility.
All right. Satish, you know, while you were away, that's why great to have you back. You know, certain questions that you need to answer because we need to see it from the prism of legalese, Satish, you know. First, does the governor have the right to reject a bill or not?
Actually, as per the constitution, if you see the phrases words by word, the word reject has not been stated anywhere in the constitution.
Okay.
But however, the powers have been given in case it is against the constitution, or in case it is opposed by the directive principle of state policy, or in case it is the public interest of the state as a whole, or in case of national importance. On these grounds, the governor has a right to return back to the assembly to consider and give their opinion once again. But I want to refer, the word reject has not been stated in the constitution as far as my knowledge is concerned.
All right. Now the thing is
to
delay.
See another situation. I'll come to that point.
No, wait, Satish. Wait, Satish. The thing is to keep it in abeyance, a bill, whether he, you know, sends it to the president or takes it back or sends it back again. Because the Sarkaria Commission says very well, if any bill is pending in the state legislature, governor may not send a bill to the state legislature concerning the same. So it does have a right. Is there a time period specified that the governor has to come back within 6 months or more?
So far, as per the constitution or maybe the rules or maybe any precedent by the Supreme Court, the time frame has not been given so far. Even in the present Tamil Nadu's case, this Tamil Nadu government has also sought before the Supreme Court to fix a time frame that has not been done so far. However, in the recent case, I remember the case of Rameshwar Prasad's case, as soon as possible has been mentioned by the governor. Any decision taken by the governor should be done as soon as possible. But still, there is no definition or maybe an explanatory meaning for the word as soon as possible. But this is quite unfortunate, we can say, that the conflict between the assembly and the governor is going on in many states. But in this case, I feel the Honorable Governor, he's clearly saying, even before the press, let the CM go to the Apex Court for any clarification. This otherwise means that he has got a confidence and he would have got a legal opinion about the bills which are pending. So yeah, I feel the governor to some extent having the confidence that these bills are against the certain the principles of that is principles of state policy or maybe the national interest.
So he is confident of it. I mean, you are right. The way he said, you know, that I welcome it. I mean, maybe he is also, I mean, Arif Mohammed Khan is an erudite
and
man.
Sudha, one more point I would like to add. One more point I would like to add. And generally, we are saying that the elected members of the assembly are they are the representative of the public, but not the governor. Governor is only a constitutional authority. I, to some extent, differ from this point, because even a governor, in case he is appointed by the constitution according to our principles, we say he is appointed by the constitution and by the president. If that being the case, you take the constitution, the preamble. The preamble says by the people, for the people, of the people. In that case, it says very clearly, even the governor is by the people. You cannot deny that he is not a representative of the public.
Very well said.
He is also a representative of the public
very well
the constitutional authority.
Yes, very well said. But then that, you know, makes Pinarayi's case strong, because Pinarayi says that if it is impacting in a parliamentary democracy the rights and aspirations of the common man, then which means Governor Arif Mohammed Khan is standing against for the people. You know, that can be, I am not a legal luminary, but this much law one understands. I have to go to, wait a minute, I have to go to Rajendran also, you know, he's been waiting. Mr. Rajendran, let me ask you something. And, you know, from the political point of view is that you look at Tamil Nadu, you know, every day NEET bill, it's pending. Apart from that, the governor also plays a very political role there. You know, every day he talks Sanatana, he's used the words indestructible, because Udayanidhi Stalin said eradicated. I am not holding a brief for Udayanidhi Stalin. You know, we journalists are non-partisan completely, right? So every day he talks about Tamil Nadu, whether it should be Tamilagam, it should be Tamil Nadu. He talks about the superiority of Sanskrit and about Hindi. Every day he is saying something, you know, which you also saw his address in the assembly. You know, there was a lot of controversy. Don't you think, and I am not talking about Tamilisai Soundararajan here, because in that case she has said there is no protocol. The Chief Minister refuses to come for Republic Day also for the flag hoisting. You know, no one comes for the functions that I hold. Tamil Nadu refuses at home, tea party with Governor Ravi. Every day Ravi seems to be the enemy. Don't you think that governor also on his part plays enough politics instead of being this figure who's there to accomplish certain duties, Mr. Rajendran?
So Sudha, you know, there is something called convention, and Satish would appreciate, there is something called constitution. So, you know, the democracy, in a democracy, we don't just go by constitution, we also go by convention. So, you know, the convention says that the governor should help the legislature and executive to help in implementing and executing the bills or the policies. Let's keep that on one side. You know, Sarkaria Commission said one very important thing which, you know, people are not executing. I mean, you know, even before Sarkaria Commission, if you look at from 1957 when the governor role came into play, you know, they were appointed. I mean, you know, the credibility of the governor is at stake, and it was at stake. And, you know, nothing has happened to that in terms of, you know, appointing people of, you know, greater credibility. When I say credibility, it's suggested that, you know, people should not have been in politics or should not be close to the ruling party or of the ruling party. They should be people of eminence, and most, you know, preferably from a field where they have gained respect and have gained
that's
skill.
an ideal situation.
And, you know, that is the respect one gets. And that's missing here, and that is the reason you see the conflict.
Right, I think we've
point on again on the Constituent Assembly, where it was said, you know, one person should not be seen as standing to object what a whole team of people elected by the people
Right. I've
have
got the point.
legislated.
Yeah, I've got the point. Gokul Chandran, I want to come to you. Gokul Chandran, you know, it's not possible that, I mean, look at an ideal situation where the governor works in coherence with the chief minister. But these three South Indian states, and I'm also going to include West Bengal here, there is no cohesive, you know, kind of methodology to this. Tamilisai Soundararajan and KCR can't see eye to eye. Pinarayi is the same case. Stalin is, I think, it tops the charts when it comes to this. So, I am asking you, Gokul Chandran, how many man hours is wasted in this? How much of taxpayers' money is wasted in all this? I can sit on a bill, but the delay it is cost, the delay that it causes in terms of money, in terms of man hours is terrible, and the chief minister or every state also has to understand that this is not an ego clash. It's about getting work done, Gokul Chandran.
Yeah, Sudha, when Congress party was ruling India, see, we also had governors of the party, they're politically affiliated, but once they become governor, once they move to Raj Bhavan, they are mostly impartial and they work together with the chief ministers and the state government. That is what usually happening. After BJP came to power, when these people were appointed, because whenever they lose elections, the political leaders of BJP lose elections.
Oh, come on, Gokul. Mrs. Gandhi was the queen in all this. I belong to that generation. No, don't forget.
Yeah, Sudha, no. Yeah, Sudha, let me complete. So, see, take the perfect example of Tamilisai Soundararajan. In Telangana, she objected the KCR's people, the party people, being appointed as MLC under governor's quota. The same way as Lieutenant Governor of Puducherry, what she did, she appointed BJP people, the BJP political people as MLCs from Lieutenant Governor's quota. Usually, these MLCs were appointed, the governor's quota is for eminent personalities, maybe from the sports, maybe from cinematic field, and they are usually the journalists and all, they were given that quota. But today what is happening, these governors, they are using their authority to appoint.
Yeah, that's what Tamilisai has
people.
done. You're right. Tamilisai has rejected two nominations. She says that they are technically misfits, you know, like there you on the screen right now. You know, Dasaju and Kurra. Yeah, she says no, and KTR therefore says she's unfit because these two belonging to the backward caste are complete fits for these two positions. But the point of the matter, go on quickly.
Yeah, in Pondicherry what she did, she appointed BJP people as MLCs under the governor's quota.
So this is what, no, all I'm saying is that the moot point is, that's what I was telling Mr. Rajendran, man hours lost, money lost, no work done. What is the point of this political slugfest? Satish, tell me something, that do you think now that Pinarayi has decided to kind of go to the Supreme Court and perhaps taken a step, you know, a forward step, you know, what can happen? Because it will not really, you know, either make the governor give assent to the bills or the removal of the governor. Am I right?
No, I feel we see onus on part of the Chief Minister of Kerala to file his grievance before the Honorable Supreme Court. And definitely Supreme Court will hear his petition because it is some sort of a slightly a difference in the constitutional interpretation. So definitely Supreme Court will hear his petition. And in that case, as the Honorable Governor said very openly, that Pinarayi Vijayan has to give his opinion very clearly and what was the objections raised by the governor, and this explanation is ought to give before the public. But generally what happens in case of the relationship between the governor, the protocols or maybe the constitutional provisions and the relationship, such as secrecy are coming out to the public now, which is not required at all nowadays. Because the relationship or the administrative executive actions between the chief minister and the governor are within their four walls. Now it is coming to public. Why the governor is also coming out to the public? Because the chief ministers and the ministers are coming out to public because as they feel they have the right to come out, and now the governors, they are also forced to come out and speak to the public directly, expressing their opinion, why they have got, they are rejecting or why they are having their own conflict with the chief minister. So here, that also that has to be observed. But I feel that Supreme Court definitely will give a clarity in this regard, because it's a high time that the conflict, especially between the governor and the state, has to be stopped at one
It has
point
to
of time.
stop. Yeah, absolutely. It is high time, because again and again it keeps repeating itself, and like you say, you know, there comes a time when it has to stop. Mr. Paul, let me come to you. Mr. Sebastian Paul, I want to ask you, for the benefit of the viewers, I mean, the two bills, the university bill and the public health, what are the other bills which are pending before Governor Khan, sir? Sorry, sir.
Already there are 3 bills pending for a long time. One is the Loggerheads amendment bill. Loggerheads bill, even the Congress party has asked the governor not to give assent. This is another story. Then Loggerheads, then the university bill, and there's a public health bill. Nothing wrong or obnoxious in these matters. I repeat the matter, if the governor has his own reservations, he can express it in so many ways approved by the constitution, but the total silence and inaction on his part for an indefinite period, a prolonged period, as I said, what 22 months a bill is pending before him. It is absolutely wrong and cannot be approved, and the Supreme Court will have to be interfere in the matter and give a clear direction to the governor.
Right. Mr. Rajendran, you know, do you also concur with what Mr. Sebastian said and also what Satish said, that the time is now ripe, because this keeps repeating itself, for the Supreme Court to actually take serious cognizance of this, that how long, I mean, what happens when there is a serious slugfest between a chief minister and a governor? How long will this go on for? Look at this NEET thing. Of course, it's a DMK's political, you know, they are flag bearers of anti-NEET. But the point is, on a serious note, any kind of a bill like just now Mr. Sebastian Paul said, you know, 22 months. Don't you think it's high time that, you know, the Supreme Court takes cognizance of this?
So, you know, all of us here have studied political science probably in our 10th and 11th. And, you know, or even probably in the middle department when we were. And the role of governor, we have seen, has been, you know, kind of seen as interpretation of what the person should do. So, you know, again, you know, it is the person who sits on that seat has to demonstrate that what character is in terms of serving the public. You know, if we keep, you know, becoming an obstacle and not serving, it's going to send wrong signals. And I agree with the two speakers. It is time that the Supreme Court should interpret the role of the governor. I would go a bit further, and, you know, probably the Kerala government should make such a request to the Supreme Court that it makes the role of the governor, in particularly in the legislative matters, more clear and more transparent, so that the people who voted a government,
you know, but
do
it's
not suffer.
Yeah, I hope the apex court does that, the honorable court does that, but it's a conundrum, because as governor, if he keeps quiet, then he's supposed to be a rubber stamp. If he speaks out, he's supposed to be getting into a slugfest with the chief minister. So I guess the only solution is for the apex court to come and say this far and no further. But you are right, all of you are right, you know, that the slugfest in 3 southern states, this time around it's Pinarayi who's going to Supreme Court, but you know, whether it's Tamil Nadu with Muka Stalin or whether it is K. Chandrasekhar Rao, it has actually transgressed every level of decency now, and I think this, it's time that the Supreme Court intervenes. Thank you. I want to thank all of you. Have completely run out of time. Satish, thank you so much. Mr. Sebastian Paul, many thanks for joining us. Mr. Rajendran, it was sheer pleasure. Gokul Chandran, as always, thank you very much indeed, gentlemen. And on the South Indian, yet another debate, and which involves all of us. It involves all the preteens, all the prepubescents, all the adolescents. So therefore, this is something, like I said, is very significant for the health, mental health of this country. What should be the age of consent for adolescents to engage in sex? Please note that when analyzing this question, we should also take into account the times that we live in. Anything is not ever in isolation. It is about what are the times. I shall give you all the details, but before that, a bit of history to put things in perspective. It was in 2012 when the minimum age of consent for sexual intercourse was raised from 16 to 18 years. But then in the recent past, both members of higher judiciary as well as civil society raised concerns over the criminalization of consensual relationships between adolescents. So, what they are basically saying is that if a couple who are, for example, say 16 years old and have had sex with or without consent, with or without, even in such a situation, the male, if they are heterosexual couple, can be deemed to have committed rape on the girl in case there is a complaint. The reason being that the POCSO Act says that any sexual activity with or without the woman's consent, if she is below the age of 18, shall be considered as rape. One of the most significant observations came from none other than Chief Justice of India Chandrachud, who said, and I am quoting him here, the POCSO Act criminalizes all sexual activity for those under the age of 18, regardless of whether consent is factually present between the two minors in a particular case. Raising concerns over the rise in the number of cases under the POCSO Act where consenting adolescents engage in sexual activity, Chief Justice urged the legislature to review the age of consent under the 2012 Act. You may now ask me, what if the couple marry? Suppose they get married. First of all, if someone marries at the age of 16, it is illegal. And even if, let us say, it happens in several rural areas, despite that it is illegal, even if, then under the ambit of engaging in sex, a large number of consenting couples can be prosecuted under POCSO. And in this case, if it is a heterosexual marriage, the husband could be jailed for up to 20 years under the law. Therefore, after much discussions and deliberation, the 22nd Law Commission, which submitted its report to the Union Law Ministry, has opposed reducing the minimum age of consent from 18 to 16 under the POCSO Act. Now, there have been several arguments about 16 versus 18. There are of course different age of consents in different countries and mostly based on cultural parameters, as well as, and this is very important, awareness amongst preteens and teens. Listen in to what Law Commission of India Chairperson Justice Rituraj Avasthi had to say.
We have finalized the report on POCSO Act, and the other report we have finalized with respect to online FIR.
And we submitted the report will be released today?
Reports we have finalized and we have sent it to the Law Ministry.
So on both the agendas the meeting happened, but on the third agenda, one nation, one vote.
One nation, one election, we found that some more work is required to be done, and we are still in the process of finalizing the report.
Now, the United Nations formally defines adolescence as the period between 10 and 19 years of age, and young people as between 10 and 24 years of age in Southeast Asian region. Even under this, a nation's law, while keeping in mind its cultural mores, have to be taken under consideration. But the most important aspect, ladies and gentlemen, about the age of consent for having sex is only awareness. But what awareness? Of the law, of our bodies, and first and foremost the choice of whether one is ready to engage in sex or not. It is a choice. I keep saying this, it is a choice. If you ask me, with the kind of complexities in India. We are culturally so different, and that's what is the beauty of this country. I feel, I am sticking my neck out, I feel it shall take a serious churn to come to any decisive conclusion about 16 or 18. So, the South Indian shall now say goodbye, Vanakkam, Namaskaram. For all the other news and analysis, keep watching News 9 Live. Thank you.
Mr. Murthy, 25% of our population is below the age of 15. How do we